Hi, everybody. It's Whitney Emmanuel with Strategic Visionaries bringing you Money Smarts for today. And today's topic will be about estate planning. Now, I'm not going to discuss the documents and how to form those and give you specific legal advice because that can only come from an attorney. But I do discuss this a lot with my clients because what we can control is how you set up your accounts and how you set up your beneficiaries. And that matters a lot when it comes to estate planning. So from the financial planning perspective, that is very intertwined with estate planning. And I work a lot of times with estate planning attorneys on my clients' financial estate plan. So it's a big part. So what I really wanted to just start with the basics, right? So what is estate planning? It's managing the assets that you own and when you pass away. So everybody has some type of asset and everybody's estate goes through probate because not only is that the place where your assets end up going if you don't have a type of trust set up to avoid probate court. What also happens is that this is where your debtors come and they try to get that debt paid back. So that's also very important to know because your loved ones who are managing your affairs when you pass away will have to handle these things. So it's important to have that in order because of course, it's not about you and during your lifetime, but it's about really lessening that burden for the people that you care for and your family and the people that you love. That's why estate planning is so important. And this is a topic that I talk to a lot of my clients about because I find it to be incredibly important. So one common mistake, or really it's not, it can be a mistake if it's done improperly, but one misperception about estate planning are beneficiaries. So you have with all of your accounts, especially IRAs and 401ks, those require you to have a beneficiary, okay? So let's say you're married and you have a 401k and your spouse is your beneficiary on that. But let's say you get divorced and your spouse is still the beneficiary. And you change your will. And your will, which is a legal document, says, I want this money to go to my children and I want my sister to manage it for them. Those are the wishes that you put in your will. But your beneficiary is still your ex-wife. When you pass away, that beneficiary designation actually it supersedes that will, that document. So that's one very important thing that I always tell my clients, and that's something that I actually set up for my clients are your beneficiary designations. So think very carefully about those beneficiary designations. It's extremely important. Another thing too is that any accounts that aren't IRAs or 401ks, so just an individual account that's taxable, it's not a tax shelter, it's not a specific retirement account, or a joint account that you may hold with your spouse, those accounts don't automatically have what's called a transfer on death title. So I always recommend that people add that. I come across a lot of accounts that I don't manage that clients show me. And I say you need to get a transfer on death on this because with the thing about beneficiary designations, the reason that the will doesn't have any power over those is because beneficiary designations actually bypass probate court. They don't have to go through probate court. Same with all your life insurance. So that's the benefit of it. It's the benefit is that it doesn't have to go through court after you pass away. The negative is that if you aren't paying attention to that and you're not updating those beneficiaries, that's where you could run into trouble. So this is one of the biggest lessons that I tell my clients. I'll just to talk a little bit more about the basics of the documents that, like I said, I do not draft, but everybody should have a will. Everybody should have a power of attorney. Everyone should have a healthcare directive. And if you have children, you should have guardianship established. So those are the 3 to 4 documents that are necessary for everyone, no matter how many or little assets that you have, because the documents that you have in place say how you want things to be handled. It says who you want to manage those financial matters after you pass away. And that matters because otherwise the court appoints these things based off of your family. But what if you don't trust a family member and that's who the court appoints? But if you have a legal document appointing them, then you've got that under control. And so you want to make sure to work with an attorney on these things. You could also consider a trust. And I've managed trust assets before. So what does that even mean? A trust is a separate entity and it holds your assets. There are different kinds of trusts, lots and lots. And that's where, I can talk about them. I'm familiar with them. I've seen a lot of them. But at a very minimal, basic level, when you have a trust in place, you have assets that the trust owns. And so when you pass away, just like the life insurance or IRA, those assets bypass probate court. Once again, the reason that you don't want to be in probate court is for a couple of reasons. And again, probate court's not bad. You can do a simplified probate process if you have all of the documents in place and everything's very clear. But if it's unclear or you don't have documents in place, you can get stuck in probate for a long time, and that is very costly. Okay, so one, it takes away from the assets that you would otherwise like to leave as a legacy. And number two, it's public. So oftentimes people don't want all of their assets and all of their estate on public records. So that would be another reason to do a trust. And then if you are above estate tax limits, that there are some trust techniques that you can implement that could prevent from the paying of estate tax. At a federal level, that's just over $10 million. In Minnesota, I can't remember the exact amount. I believe it's just over $2 million, where if your estate's worth that, then you would have to pay probate tax on either Minnesota state tax. It's much lower, like I said, about $2 million. And then with federal, it's just over $10 million. So again, things to discuss with a financial advisor and an attorney, but I just wanted to pass on just these few tips to you on the basics of estate planning and some common mistakes that people make about beneficiaries and the titling of assets. So I hope you have a beautiful and abundant day, and I'll talk to you next time. Again, it's Whitney Emmanuel with Strategic Visionaries giving you your money smarts.